Welcome to Case Closed by John Swallow, and we have former Attorney General John Swallow here. John Swallow has worked in both the private and public sector, first as a lawyer for a multinational company, and then as the Attorney General of the state of Utah. Even more powerfully, he defended himself against false charges and beat the government to clear his name. Well, John, we have a hot topic to talk about today, and it's Roe v. Wade. And one thing that I want to start with is the historic case, going back 50 plus years. How did we get to Roe v. Wade, and what happened with that court case? What did it look like on a constitutional level? All that.
Well, thank you for having me.
Yeah.
It's a privilege to be here and talk about such a very hot topic right now.
Yeah.
And let me just preface my remarks by saying that it was a shock to everyone.
Yeah.
That a case decided in 1973 was overturned just in the last month by the Supreme Court of the United States, which really sets the policy of the constitutionality of the laws in our country. And I'm not a constitutional scholar. Certainly have practiced law for more than 30 years, and as you've mentioned, I served in the state legislature, and I also was the Attorney General for my home state. And so
you have a lot of background in this.
Right, and I was actually sued as a defendant in a same-sex marriage case just before the Supreme Court legalized same-sex marriage. So, I do have some experience in these controversial areas.
Yeah.
So Roe versus Wade was decided in 1973. And the best way to become educated on what the historical underpinnings were of Roe versus Wade, honestly, is to read the Dobbs case, which was just decided with Justice Alito being the author of that. So if you want to really get up to speed on historical underpinnings of Roe versus Wade and his take on it, when I say his take, I mean we in this country we determine what constitutionality means by following the writings of the Supreme Court. So in this case, 5 justices agreed that this was the truth about Roe versus Wade. And so just read the first few pages of of the Dobbs case, which was just decided, and you will understand a little more than you could have ever possibly hoped to imagine about Roe versus Wade. Roe versus Wade, I think, came as a real surprise to a lot of the scholars back in 1973, because according to the majority opinion in the Dobbs case, for I think 30 states, just immediately preceding Roe versus Wade, abortion was illegal. In some cases, a criminal act. And so we read in a case that was passed in 1997, and I'm going to read a quote from that case right here. It says, provisions have been held to guarantee some rights that are not mentioned in the Constitution. So abortion, the right to an abortion, was never mentioned in the Constitution. The 14th Amendment and the Due Process Clause, which was seen as the primary justification for the premise set by Roe versus Wade that a woman has a federal constitutional right to abortion, the word abortion is never mentioned in the Constitution, not once. Okay? So then the court looks to what it calls such right must be deeply rooted in the history and tradition of the country. Implicit is the concept of ordered liberty. And so what that Supreme Court case said back in 1997, which had nothing to do with abortion rights, okay, was that if it's not a right that's kind of codified specifically in the Constitution, it has to have a strong support historically and traditionally in our nation. And it has to be a part of what we recognize as ordered liberty in our country. Justice Alito, in his majority opinion in the Dobbs case, said that Roe versus Wade was not founded on an express right in the Constitution of abortion, and was not actually steeped in tradition, in historical concepts in our country before it was even passed. And so he basically said it was wrongly decided and should have been rejected from the very beginning. And those people who say that the last 50 years are indicative of a precedent. His argument, in his opinion, was, and supported by, again, the justices, the majority of the court, was that you can't form a precedent on something that was wrongly decided in the first place. That's not an excuse. So getting back to what this case did, I hope that answers the question of the basis, the foundational basis for overruling Roe versus Wade. And Casey, which was a case decided a decade or more later, that rejected the primary holding of the different trimesters. And basically, Roe versus Wade came to viability versus non-viability of a fetus, and whether a woman had the right to control her body before her fetus became viable under the law. Okay? What the justice did a few weeks ago was basically say that there's not a constitutionally protected right that a woman enjoys relative to a fetus just because the fetus happens to be viable or not viable before delivery, right? And that the legislatures of our country, federal or state, really have the right to determine and police the protections of an unborn fetus. Now, if I can say that in a clearer way, basically all the Dobbs case did was say there's no constitutionally protected right to an abortion. We're going to return the power to the legislatures and let them, state by state or Congress, if they choose to act, make the determination about whether a person has a right to an abortion. And that's why you're going to see a patchwork of abortion laws in this country. You're going to see the blue states saying this, and you're going to see the red states saying that. And depending on where you live, you will have more or less restrictive rights to an abortion. And the justices on the Supreme Court recently believe that that discussion is better preserved for the democratic process in each state or each jurisdiction that considers that issue. And so you'll see, for example, in my home state of Utah, which is fairly conservative, you're going to see more restrictive abortion rights than you're going to see in the state of New York, for example, where almost any kind of abortion is allowed under state law. And that's kind of how it works. So the decision recently didn't outlaw abortions. It simply allowed the legislative bodies in individual states and in Congress to make those determinations independent of any perceived or implied constitutional right, which the Supreme Court has now rejected, overturning Roe versus Wade and Casey.
So how do Supreme Court justices even approach something like that? I don't know if you have any background on that, but it seems like a hefty job to approach something that large and then start dissecting it. Do they start with opinion pieces? What do you have any background in that?
Well, the way the process works is that when a law is passed by a legislature, whether it's the Congress, which is a federal legislature, or whether state-specific, there are 50 states, right? And so there are 50 different legislatures. The law is passed, it goes into effect. Then if some organization or some person objects to that law and describes it as unconstitutional, that person or group files a lawsuit seeking for a federal court to enjoin the impact or effectiveness of that law.
So are you suing the government over this? Or are you?
Well, yes, in many cases. So, for example, when I was sued as the Attorney General over same-sex marriage legislation, a constitutional amendment actually, that had been passed in the state of Utah, defining marriage as between one man and one woman, right? Then someone sued the governor of the state, the Attorney General of the state, who was me, and I believe a clerk or two of one of the counties, right? And sued them as defendants, and sued as plaintiffs against defendants. I was one of the defendants, and sued in federal court. Then claimed that the law violated the U.S. Constitution. Okay, so then that goes through the process of the district court, and the district court decides whether, based on precedent, based on prior case law, like Roe versus Wade in this case, okay, the law is unconstitutional. And the district court made a decision and said the law passed in the Dobbs case was unconstitutional and enjoined the implementation of that act or stopped it from going into effect, right? So then it went to the Court of Appeals. And the Court of Appeals, looking at Roe versus Wade and Casey, likewise recognized a constitutional right of a woman to have an abortion and enjoined at the appellate level that law from going into effect. And then the Supreme Court, in its discretion, decided that it wanted to hear the case. In other words, they wanted to re-examine precedent and Roe versus Wade and Casey to see if they felt like, in this case at this time, fundamentally those cases were flawed and it needed to be re-examined. So the Supreme Court had to decide whether the law passed by the state of Kansas in the legislature was a valid law in light of the precedent of Roe versus Wade and its progeny, including Casey, right? And they decided to hear the case, examine the case on the merits, and they ultimately decided on their vote, majority vote, that the law passed by the legislature in the state of Kansas and sought to be enforced was constitutional, and that Roe versus Wade was unconstitutional, thereby affirmatively stating that a woman does not have a constitutional right. She may have a statutory right in an individual state, and if Congress gets involved, she may have a statutory right passed by Congress, by the legislative body, but there was no embedded constitutional right under the 14th Amendment due process clause or any other provision of the Constitution for a woman's right to an abortion. And that's all this law says.
Okay. Well, I could see someone out there who is listening to us and might be a little confused because they're just watching TikTok and they're like, oh, it's illegal. But it's not illegal. It's just unconstitutional. And now it's going to go state by state. And if Congress gets involved, then it'll get...
Yeah, I want to say this again. The right to an abortion is not a constitutional right. It doesn't mean that abortion is unlawful per se. It just means that it's not a protected right for a woman under the Constitution. So if the state she lives in says it's okay under certain conditions to have an abortion, she can still have an abortion. The Supreme Court didn't say that you can't have an abortion or it's unlawful. It just simply said you don't have a right to an abortion unless the legislature says you do. It's not an embedded constitutional right. If it's a right at all, it's going to be passed by a legislature, okay? Like the right to drive a car is not necessarily a constitutional right, but it is a right that's granted by the state, and certainly within the rules of you have to have a driver's license. You can't go over a certain speed limit. You can't be intoxicated. And they can regulate the right to drive a car on a public highway, right?
Yeah.
Right? And same with abortion. It's not a constitutional right to have an abortion, but the state can regulate it and say under these circumstances you can. And here's what you have to do and here's when you have to do it. And that's going to belong to the states now and to the legislatures of our country to decide under this decision recently in the Dobbs case.
So it sounds like really this isn't like it's no longer a Supreme Court issue. You have to go talk to your legislators. You have to get active in your community to get what you want for or against.
Right. So what happened was in 1973 when the Roe versus Wade case was passed into law, every debate, every piece of legislation restricting the right to an abortion basically hit a brick wall because every legislature knew that they couldn't over-regulate or really regulate much about abortion without infringing on a constitutional right that a woman had to have an abortion under certain constraints set forth in Roe versus Wade, right? Basically that until viability, as defined by Roe versus Wade court, no legislature in the country could restrict the right of a woman to an abortion. It basically was a decision between her and her doctor and her family. What changed with this decision was the Supreme Court now says that the states can regulate that because it's not a constitutional right. That Roe versus Wade got it wrong. And that's what our Supreme Court has said. So now, because there's no constitutional prohibition stopping legislatures from regulating that activity. Now the legislatures can go ahead and regulate the activity. And it'll be a state-by-state process until or unless the United States Congress gets involved and passes a national law granting a right of women to an abortion under the law versus under the Constitution.
So could you see something similar where you were getting sued for gay marriage rights, something happening like that again where they sue their governors and attorney general, and almost like the exact same process with you, where they would just sue the government again for something they would want?
Well, so for example, my home state has a fairly restrictive abortion law. There was a trigger law that if something happened in Roe versus Wade would go into effect. Someone conceivably could sue the governor of the state of Utah, the attorney general of the state of Utah, and try to enjoin that law from going into effect. And I think they actually have. That will go through the court system. The district court will then hear briefing and argument, and the people defending the state's right to pass that legislation will cite to the Dobbs case that was just passed and say Roe versus Wade no longer applies. The Dobbs case applies. There's no constitutional right to an abortion. Therefore, this law is constitutional that was passed by the state legislature and should not be stopped or enjoined from going into effect. Then once the district court rules, whichever way they rule, and I can't ever predict what they're going to do, they're likely going to follow the Supreme Court in what it just did, right? Then if someone wants to appeal it, they can take it to the 10th Circuit Court of Appeals, because that's the circuit court that deals with Utah federal questions. And then, depending on how they rule, they'll follow the Supreme Court precedent in the Dobbs case. And that's how it will go. And if they don't, then the Supreme Court will likely intervene and strike down their decision.
See,
but that doesn't happen very often. I mean, the appellate courts pretty much follow the Supreme Court precedent. If they don't, they're going to be stricken down.
See, I love, you said previously and you said again and again, how the law is a game. And it's a game that, I forgot the video you put out, but, at the beginning of the day, you say, play ball.
Yeah. Yeah, when we pass laws, and it's a very important process, but if you don't understand the rules, like in a game, then you can get stung by being outmaneuvered by people who are in the political process. And I described that when I described how legislation is passed. It goes through committees, and you have debates on the floor of the House, and you have certain rules and procedural rules and things that happen. And in the courtroom, you have two sides, just like in a game, it's a contest, right? In legislation, when you pass it, sometimes there are two sides, it's a contest. You can see with a divided court, there are two sides, sometimes philosophically, and it's a contest. And there are rules to that contest. It's a very important contest, but it is a contest, and there are rules, just like in a game. And you have to take it seriously. Because real rights are at issue whenever you deal with legislation, litigation, or anything important in our lives, right? Real consequences can happen if you get it wrong or if you get it right. And how you play the game makes a real difference.
Well, I think that about wraps us up, John. Thank you so much for honestly just opening up how the game is played, how things might happen. Obviously, you can't tell right now, but how we even got here in the first place. So thank you so much.
You're welcome. It's always my pleasure to try to say something that may help people understand what's really going on out there and what is happening and what's not happening and the impact it has or hasn't on people.
Well, and thank you for those at home for joining us today, talking with former Attorney General John Swallow on Case Closed.